So good morning, everybody. Welcome to another edition of Sunday School. We're joined today by Davison, legal researcher, YouTube phenomenon, and I don't even know how to properly describe her. She's a men's rights activist. Certainly, she's got. If you haven't seen her YouTube channel, you need to look her up on YouTube. Diana Davison. She's got more than 100,000 subs from all over the world. And she just speaks truth, which is what I love about her, and why we've created such a connection. She's also the founder of the Lighthouse Project, which supports the falsely accused and wrongfully convicted of sexual assault, which is a completely unique structure. You may be familiar with Innocence Project or Innocence Canada, but they deal with wrongful convictions strictly relating to murder and DNA evidence, so they can't help people who are accused, either wrongfully accused or wrongfully convicted of assault or sexual assault. And that's where Diana's kind of heart and soul and specialty is. So Diana, welcome. Nice to see you. Thank you very much for being here today.
Thanks for having me.
So I got a couple of questions just to kind of get the ball rolling. The first of which is, for guys who are kind of newly charged, we've all been advised, not to speak to the police. But when you find yourself in a position where, you get a call to a lawyer, or when you're selecting a lawyer, what are the kind of questions that you would suggest people ask when they're kind of shopping for a criminal lawyer? And I guess the second part to that question is, if you have found a criminal lawyer, or you take the first option that's made available to you, and you find that you're not satisfied with that person, at what point should you consider changing counsel?
Yeah, I mean, it's a difficult question. And first of all, I want to make it clear, I do work at a law firm. Another podcast that you can check out is called Not on Record. It's a podcast I do with Joseph Newberger, who's a criminal defense lawyer in Toronto area. He works in a larger area too, but we specialize in sexual assault cases there too. That's kind of why we connected with each other. But I'm not a lawyer, so I can't give legal advice. And but I can share with you a lot of the experiences that I've had. Hiring of a lawyer is a very difficult decision, especially because at the time that you're charged, most people are in a state of shock, and sometimes depression. There's a lot of fear, and it's just a world that most people don't find themselves in. Most people don't actually end up being charged with a crime. So, in these cases, it comes out of the blue, and sometimes even years or decades later. So there's a lot of stuff going on to process. And of course, choosing a lawyer is going to be important. They're all expensive. And I always say to people, don't worry about the money side of it. Do what you can. I know some people can't afford a more experienced lawyer, so they go for flat rates or whatever. But if you don't get it right the first time, it doesn't save you money, because then you have to pay for an appeal. And if you're lucky and win an appeal, then you have to pay for a retrial. So you really just want to try and get it right the first time. And as soon as you're charged, you have to set a date for another appearance, which sounds scary, but it's really just a date to determine whether you have disclosure. Set another date. They're really just called set dates. But so you have a little bit of time to make a decision. And if you're hiring flat rate, the problem is that at a certain point, there's no advantage to the lawyers to do a lot of extra work on the case, because they just start losing money. They're not making anything more. And we do have a problem right now with court dates being vacated when you finally do get a trial, that we get there and there's no judge available, and so another date has to be set. This is all, it's a massive problem for the accused people, because it all costs money. The lawyers have dates booked for court, and then they have to rebook and have new dates set. And we'll get to this later, but unfortunately, complainants now get assigned lawyers, so they get all of this for free, and they get their own representation in pretrial motions. But the system is broken in a number of ways, and the reality is you just have to push through it and do what you can. So I think the most important thing when you're looking at a lawyer is to feel that there's a connection, that they care about your case and they care about you. And that you're not just, because there's some lawyers that do volume practice, so they don't pay as much attention. And also, I think one of the more important things to ask is if there's going to be preparation time. There's some lawyers who only speak to their client and prepare them for testifying for like an hour a day before court, whereas we spend days, explaining the process, getting them people comfortable, because it's scary when you testify, and those nerves can end up coming across as being some sort of disingenuous, or that it affects your credibility if you're not comfortable. So you want to have a good rapport with the lawyer. At the same time, if you inundate them with too many questions and regular emails, then it can cause some tension. So and you want to have somebody like we say to clients too, because it is stressful. We say, you've hired a good firm, just trust us to do our job. We'll let you know when we need something from you. And the reality is it takes at least 18 months to get to trial, even in the lower courts. And Superior Court, they have better judges. You have the option for a jury, and which we're not too keen on anymore now that the selection process has changed for juries. But there's a bigger chance too in Superior Court that when you get there, there's not going to be a judge available. It's been a major problem recently. So, but really, it's just kind of, you have to go with your intuition. And the reason, just to touch on the first thing Gavin said, the reason that you don't talk to the police when you're arrested is because you don't actually know the full accusation against you. The police are permitted to lie to you. They'll make it sound like they're your friend, but they're not. They're there to lay charges, and they're there to lay as many charges as they can. So really, there are opportunities that we can get into, which I'll be discussing when we talk about later about the new rules of evidence, that will give you an opportunity to try and tell your side of the story in advance. But everything you say to the police locks you into stuff when you're in a state of stress, and and if there's alcohol involved in the evening, and maybe you're not quite sober, you just want to take your time and have a controlled statement when you do give evidence, because you always keep in mind their job is to arrest you.
It's certainly good advice. So I guess the second part of the question, a lot of guys, when we're on kind of the weekly calls, a lot of guys express some sense of dissatisfaction. They're constantly reaching out to their lawyers and they're not getting a response, or they're not getting a response that's meaningful. And I know, you obviously have a look at this from the other side, from working within a law firm. But when you're in this kind of state of shock or state of stress, and you're just looking for a response from your lawyer, some guys choose to switch counsel when they don't get a result or don't get a response within kind of a week or 2 weeks. And you're just in such a traumatized state. And I felt this personally. You just want answers. So I know that there are some downsides to switching counsel, but there's also a point in time where if you really feel like you don't have a connection with the lawyer who's representing you, maybe it is time to switch counsel. Can you kind of give any direction on that?
Now, generally, when a lawyer gets off record, and it happens, in every law firm, regardless. I mean, we have some people who switch for different things or whatever, and it doesn't mean that the person's a bad lawyer. Lawyers understand that, but we call it a breakdown in communication. And so, not receiving an email for like a week or two response can be for a number of reasons. But if you repeatedly are asking really basic, simple things and you're not getting any response, then that would be definitely a sign that you should maybe, say that you're concerned about maybe switching representation. At which point, if you still don't get a response, then you absolutely want to change. But don't rush into that. The reality is when you hire, you generally will start putting down payments into a trust fund. And when you switch lawyers, they'll find a way to bill it out. And so, we've had people who've, ended up getting nothing back from their lawyer, but they had to switch to us anyway. And so it's, it's expensive, but at the same time, if it's not working for you, you don't want to be going to trial with a lawyer you don't trust. And lawyers will always say that they're experts, that they win all their cases, and that you're in good hands and so on. So, they'll speak a good game. It really, it really can change drastically afterwards. And, sometimes, they're people too. So sometimes a really good lawyer might be going through a hard time and they're just not properly available or something. So the decision to switch is a big decision, but if you have concerns, like, it takes about 3 to 4 months to get disclosure. So there's not a lot that a lawyer can say or do about your case until they get that. Some places are faster than others. I would say after 6 months, you should have some form of meeting, communication, putting together your timeline and chronology, and feeling like they actually understand your case a little bit. And if you don't, after 6 months, if you can't get any sort of communication like that, there's probably a sign that you should, earlier than later. You don't want to be switching right before trial, put it that way. But I mean, it's really hard to say because a lot of it is just sort of personalities meshing together. And, it's good to know that the lawyer that you're hiring has a lot of experience in the type of case that you're facing as well.
For sure. So when I think lawyers do a really good job of kind of delivering the kind of messaging that an accused person wants to hear. We're going to protect you. We're going to fight for your rights. We're going to do all these things. And a lot of accused people just, and I'm guilty of this myself. I buy into it hook, line, and sinker, or we buy into it hook, line, and sinker because we're hearing all the things that we want to hear, that we do have someone who's going to fight for us. How would you suggest kind of researching that lawyer, or is it beyond something that is just a feeling that you have when you connect with somebody? Would you recommend reviewing their case law or their cases on Canly? Or
Yeah, Canly, I mean, Canly's an amazing database, but it doesn't have everything on there. So, like, if you look up Joseph on there, you'll find a bunch of stuff, and he's, written a book that's been cited a lot. He's got a book on dangerous offenders and such. So he's really well known, but it's surprising how few cases, like of the ones I've worked on with him, there's only like maybe 4 or 5 of them that are posted on Canly. And sometimes it's because of the nature of the allegations that there's publication bans, and judges don't always do formal written decisions that have like everything anonymized and such. So you can find out a little bit about them, but it's not a full picture on Canly. You can ask them to give you like examples of cases they worked on, and so usually that's within the limitations of publication bans and such. That's definitely one of the things you can ask, just if you can have some sort of like examples of cases they worked on, and to give you a sense of the other thing you could do. Well, you can actually try and go and watch them in court. It is a public courtroom, right? So and actually, that's, having said that, is a really good idea to go to a courtroom and sit in on court cases just to get a sense of what being in court is like prior to going to trial. That's something that we've, except for during the pandemic, that's something that we recommended people do.
yeah, I think that's really sage advice. Thanks for that. I guess I had a sidebar question there and I totally forgot it. So we'll move on. Maybe I'll come back to it. If there is a family law case that's running concurrently with criminal allegations, how would you suggest finding a lawyer that either A, deals with both family law and criminal law, or how would you suggest creating a connection between a family law attorney and a criminal law attorney so that there's nothing that's said in family law that might prejudice the criminal law case, or vice versa?
Yeah, and this is extremely common because I'm sure there's a bunch of people who you are participating or your have found themselves in trouble because of parental alienation, because it was in the middle of a custody dispute, or just a dispute over assets and such, is much more difficult when children are involved, obviously. And these allegations is typically referred to as the silver bullet because it's the easiest, quickest way for usually the female to completely cut off the spouse's access to all of their resources and their children, and it's a power play. So it's extremely common, and it's also extremely difficult if it's unfortunate enough that the children are the ones being made to make the allegations. Those are extremely difficult to defend against because there's a sort of hashtag believe thing that's been going on before the Me Too movement, where children's evidence is given deference, where they're not expected to be consistent. They're not expected to remember dates and details accurately. And they always just say, oh, the core of the allegation remained the same. So children's evidence really does not have the same level of scrutiny as that of an adult. And there can be some situations as well that have been overturned in appeal, where an adult testifying about events they allege happened as a child, their testimony was treated as if it was actually a child's testimony, even though the person was an adult in an historic allegation. So anything to do with children, not only is it difficult to defend, not impossible, but it is difficult. But it's also heartbreaking because this is a child who's been so alienated. And we've gone into court and shown amazing pictures of great times and the bond and the closeness between the father and his daughter, and she not even a single emotion shown from this child when she's looking at them. She's just like, yeah, whatever. Well, I was just smiling because the camera was pointed at me. And she just completely had erased all of these feelings and all of these emotions. And that's the saddest thing to see. And it's difficult because as soon as the allegations are brought, then generally the accused person has almost no access to their children. So it's heartbreaking, and it makes it extremely difficult to prepare. And then, as Gavin was saying, there's this issue about family court lawyers and criminal lawyers trying to work together. And there are lawyers that work really well with criminal lawyers. There is some strategy. It can end up taking a little bit longer because we try to put off sometimes things that are happening in the family court, ask for a delay. But sometimes the family court stuff is extremely helpful for criminal court. We have quite often used affidavits that were filed and discovery transcripts to confront complainants with things that they've said in family court. We had one case that was pretty stunning, where the woman had actually falsified and obtained a false marriage license in order to try and get assets. And she was completely busted on not only of obtaining this false marriage certificate, but of refusing to have it annulled unless he paid her out money that they had agreed to. And then the judge was saying, well, you can't stop us from annulling a marriage that never existed. But the entitlement, and unfortunately, there's groups like the Barbara Schleifer Center. It gives free legal advice and support to women who are leaving male spouses, and they kind of get a guidebook on how to use the system. So they've got a lot of support and a lot of information. It's even posted online on websites and places like Luke's Place and things like that. That it doesn't take too long for a woman to look up online or go to a female-friendly lawyer and get all kinds of advice on how to completely destroy somebody's life. So, on the other hand, men, don't get the same kind of benefits. I mean, that's why I like doing these kind of things, to try and help men get a similar kind of instruction and advice and guidance. And but really, you're the underdog going in, and we always treat every case as if we may lose, because if you go in thinking that you're going to win, the chances of being caught off guard are too high. So we don't take anything for granted. And I say that because we see this a lot, where people will come in and they'll say, well, what happens to her? That's the first thing. Instead of focusing on defending themselves, the first thing they're saying is, what happens to her? Because she's lying. I want her charged. And it's like, no, get yourself cleared, get yourself acquitted, and then you can think about that. But the anger, especially when there's family court involved, is it can make things really difficult. And it can be very helpful, but it can also be very destructive, because Family court is more like civil rules, and you can go in and they can go in, you can make an affidavit, you can say anything you want to. When you go to criminal court, there's rules of evidence, and there's certain evidence you can use in family court that is just completely unusable in criminal court.
Is there a minimum age when they can call children to testify in either family? I don't know if you know about family, but in criminal, where children would not be allowed to testify if they were under a certain age.
There's well, there's a few little complicating kind of things, and there's a couple of cases I'm very concerned about that are recent. So usually when it's a child that's 7 or less, they're just going to play. Well, actually, you can even go up to 12 um, or more. They play their video statement to the police. So when they go into court, they're not going to be sitting on a stand. They're going to be in a separate room with a support worker and maybe a support dog. And then they play the video, and then the prosecutor may ask a few extra questions afterwards to clarify a few things, but they don't actually do their full testimony. It's called in chief when they're being asked by the person who called them. But then they can be cross-examined, but it's almost always CCTV. And in fact, more and more people are getting CCTV applications up to, like, you know, into their early 20s. We're trying to fight back against that because it's too easy to be casual about it and to lie. And if you're not faced with the seriousness of the venue that you're in, sitting in an actual courtroom doesn't make a difference. And cross-examining, we found that doing Zoom trials during the pandemic, we were nervous about doing that, but it actually isn't too bad because you can see their face a lot closer than when they're sitting further away in a courtroom. And so you can pick up a lot of stuff, and it wasn't as bad as we thought. We were kind of happy about it, but it's better when it's equal playing field, so everybody's on camera. When we're live in a courtroom and everybody's just turned and watching a video screen, is not completely the same. But so children who've given statements, unfortunately, there's been some cases where they actually weren't permitted to cross-examine because there was one case, and I think it's still up to Supreme Court for an appeal, but there's one case where the child was said by a psychologist to have been would be re-traumatized if they had to actually appear in court. So the Crown was permitted to use the video statement with no cross-examination. And I don't understand how that happened, because cross-examination is the greatest tool we have to get to the truth. And the only way that they've used testimony from either a preliminary hearing or, you know, anything else, the only way they've been allowed to do that without having the person appear in person was if there had been an actual cross-examination that took place during that time. So it's kind of scary times when there's children involved. But yeah, when there's more and more people are being allowed to testify from CCTV, it means they're not at home. They go into an adjacent area of the courtroom or a separate building, depending where you are, and they go to VWAP, which is Victim Witness Services, and they're given a room with a TV, and then the documents are sent over to show them and so on for cross-examination. But it's you know, it's difficult, and the it's not as bad when the complainant is the adult spouse, because you can be a little more aggressive with them, and it's less likely that they're going to be allowed to testify from a separate room. But like I said before, it is a very different process. I'm not sure. Did I answer your question? I think I got sidetracked.
Yeah, I think you did with kind of 7 to 12 years old for the age for testimony. So I think we can all kind of agree on some level that you know, there is some level of prejudice which testifying on CCTV from a different room will give to sorry, do you remember something there?
Yeah, because you mentioned about, is there an age that's too young to testify? There was a really historic case, I think it was back in the 80s or something like that. There's a whole bunch of RV cons, but this was an exception to hearsay, where a 3-year-old on the way home from a doctor's office said something about, he put his birdie in my mouth, and you know, and And the mother's like, what? And then there was also corroborating evidence in which they found some semen on her sweater or sweatshirt or something like that. But the girl, by the time it got to court, she couldn't remember anything. And so her mother was allowed to testify about the spontaneous utterance of the child and what they were told. Normally, other people saying what the person told them is hearsay, is doesn't make something more or less true just because it's been repeated. A lie can be repeated a number of times. But there's more and more exceptions to hearsay and prior consistent statements being allowed.
Perfect. Thank you. So, I mean, we focus pretty heavily on false allegations, and we're seeing, certainly since the Depp trial, there's a lot more prevalence in the media of false allegations and the blowback from those false allegations. And on some level, false accusers being not held accountable to the same level as the accused, but are being held to account on some level. When I started doing research on false allegations, some of the stats were as low as 2% to 8%. And I remember having a discussion with you about what qualified that, or why that number was so low, because there's other research that indicates that false allegations can account for between 50 and 90%. So are you able to talk to why that 2% number exists and is used so frequently, and kind of what your experience is with false allegations in your work?
Yeah, there was, I think it was Christina Hoff Sommers did a really good job tracking down the 2% stat that came out. And I think it was something Susan Brown, or I can't remember who, but somebody was speaking at an event and said it was 2%. And then when you look into how that number was arrived at, it just didn't pan out. So, but the reason it keeps being mentioned is because people like that number. Advocates for women, women's centers and such, they prefer to say 2%. And because they know they can't get away with 2% anymore, the 8% comes from the FBI doing a study. And so now they say it's from 2 to 8%. They still throw in the 2 instead of saying it's 8%. 8% is actually pretty high, even if that was the truth. But the reality is it's near impossible to prove a negative, right? So you're saying this never happened. You know, it's easier to prove something did happen than to prove it didn't happen. And so how do they decide when something is false? First of all, it requires somebody recanting and admitting they lied. And that is very rare. Even when people in court are found, strongly found to have been creative with the truth and, you know, reckless with the truth. I think reckless with the truth was a word used in the Giangameshi trial decision. But even if those decisions are made, they'll almost always finish, the judge will almost always finish by saying that they can't be sure what happened, therefore they acquit. And so you almost never get a finding where they say, I think we've only had 2 where the judge went so far as to say, I find that they did not commit this crime. And so when you're looking at how they come up with these false allegation stats, they don't count the ones that are ambiguous, the ones where you can't be sure if it happened or not. They only count the ones, and I've made this comment before on our podcast, that to be convicted, there's no corroboration required. But to be found to have been falsely accusing somebody, not only does the person have to admit it, but there has to be corroborating evidence that they lied, because advocacy groups go on about how women will falsely recant. So they don't need corroboration to convict you, but they need corroboration for you to prove that they lied.
That's I guess the other side of things would be, if you are found guilty and then you are exonerated or the conviction is overturned, that likely doesn't play into the false allegations statistics either, does it?
No, I don't think so.
Yeah.
But that's the thing, is like, it's kind of, well, when you look at the way they formulate these studies too, and I know Christina Hoff Sommers did this. She's done some amazing work. If you haven't read some of her books, I think one was called What Happened to Feminism or something. What was it she discovered? Oh yeah. When you look at the actual surveys that they give out to determine who's been sexually assaulted, when they come to this number of 0.001% of rapes get reported to the police. Okay, they start out with a number that's insane, because they give out surveys and they'll ask, have you ever had sex when you were intoxicated? And then they'll also somewhere else ask, have you ever reported a rape? So if they answer yes, they've had sex while they were intoxicated, and no, they never reported, they count that as a rape that never got reported. But the women themselves will say, no, 70% of people in one of these studies, 70% of the so-called victims of sexual assault did not agree they were sexually assaulted. They did not call it that. They said it was basically bad communication, right? Or bad decision-making. But the people doing the survey counted it as a sexual assault. So that's why I hate when people start talking numbers, because the numbers are completely skewed, they're ridiculous, and they can never be truly known. When you ask police officers off the record, they'll say between 40 and 60% of complainants they think are lying. And there is a study that's been very disparaged by a person named Cannon, Kanin, and he did a small town study in a controlled sort of situation. And he came to the figure, and it was, I thought it was a very well done study. He came to about 50% false allegations. But of course, there's been a lot of effort putting into saying that his methodology was flawed and so on. But it's extremely high. And I don't know that we'll ever actually get them to stop saying 2 to 8%, but it's way above that.
So you mentioned Susan Brown at the beginning. I think it was Susan Brown Miller.
Miller, yeah.
Who made the quote, and that was in 1975 to the NYPD. But I think that research was completely debunked. There was actually no research behind it.
No, she just said she heard something once from somebody who said something on an occasion she couldn't recall. Yeah.
Okay, so two more questions, or two more questions from me or from the panel, and then I'll open the floor up. We've got some questions in the chat for you as well. But you mentioned jury selection process in C-75. Do you want to kind of explain what happened with that? I think that was back in October, November 2020, that ruling came down from the Supreme Court of Canada. But can you touch on that?
Yeah, this is sort of a race-based kind of myth, but that caused this change to happen. And it's been going on before, but there was one particular case that really set it off. And so the defense and the Crown used to have this ability to peremptory challenges where you didn't have to challenge a juror for cause. You could just say, you know, I don't agree to this jury member. So you could have more control about your jury selection. And then they took that away with the Bill C-75 because there was a particular case in the prairies. I'm trying to remember if it was Alberta or Saskatchewan, but there was a guy who ended up shooting an Indigenous, young Indigenous man who was actually stealing a car from his property at the time. And then there was a whole bunch of things about, oh, the whole jury is white. And the guy ended up being acquitted, but there was a lot going on. Like there was evidence that the young man had a gun in his possession at the time. People didn't know about that. But unfortunately, our Minister of Justice tweeted that she was disappointed in the jury decision the moment it was announced. And there was a huge outrage over it, saying that the reason the guy was acquitted was because the kid was Indigenous. Nobody cares about the Indigenous community. And so he ended up being sent back to retrial, and I can't remember. I think he ended up being convicted of one level of the charges, I think, but I can't remember now. So anyway, that was the whole thing, and there's no reason anybody who's a member of the justice system should comment on the outcome of a trial if they weren't present to hear all the evidence, and especially the Minister of Justice, and of course Trudeau was chiming in on it as well. So now, when you go to jury trial, you're essentially stuck with the first 12 people who say that they have no problem sitting on a jury.
So the judge gets to make that decision. The the Crown attorney and the defense attorney no longer have the right to exclude jurors. Is that correct?
Right. You can challenge for cause if there's something like, you know, if the person was to show up with a T-shirt that said something racist on it or something like that, and you're representing a client of that race, you know, you can challenge for cause. But you can't just say that you have some reservations about them. When I've been there we've done a couple of jury trials. we don't do them as much anymore because of the changes, but the judge will sometimes ask the Crown and the defense lawyer if they have any concerns. Usually, they have concerns. It's mostly when somebody says they're a student and they have some exams coming up or something like that, because you don't want to have jury members drop out mid-trial. But you really don't have any control over the composition of the jury anymore.
So I think it was Jody Wilson-Raybould who at least brought forward Bill C-75 to remove peremptory challenges from both the Crown and defense attorneys.
Mhm.
And my understanding was that it was to help streamline the case load, or to make the case load faster, so that the judge would just be able to kind of make those decisions ad hoc. Is that your understanding of the legislation as well?
Well, I mean, she can say whatever she wants to, but the public comments are made, and Bill C-75, the Liberals did a whole bunch of what's called omnibus bills. So the peremptory challenges were removed as part of a bigger thing where a whole bunch of other stuff was going on. Same thing with, I think we're going to talk about the new rules of evidence. That was part of a massive omnibus thing where they also got rid of things to do with like not being able to persecute witches or something like that. Like there's a bunch of archaic laws that had just never been removed. So they just threw it all in together, and then they hope to kind of bury some of the stuff in there. But she made her public comments, so they can say that this was something that they were considering. It was on the table for a long time, but it's not to streamline. I think the streamlining thing, if you were to say that they were doing that with any of these changes to the new legislation, would be where they got rid of preliminary hearings for anything that's maximum penalty of under 14 years. So, if you're charged with sexual assault against a child, you'd be charged with sexual assault and sexual interference. Sexual interference, they double the charge, is because they're connected. Sexual interference has a maximum penalty of 14 years. So you would still have access to a preliminary hearing, although the prosecutors can still do, I try to remember what it's called. They can still elect to go straight to court, but otherwise they essentially got rid of preliminary hearings for all sexual assault trials. And that, you could say, was to streamline it, but really a big part of it was that they didn't want to have people have to testify more than once, because they consider it too traumatic, because of course we assume they're actual victims.
Yeah, so there's there's certainly something to be said for people in court referring to complainants as victims as a method of prejudicing the rights of a falsely accused person. But I think it's probably a good time to kind of delve into the implications of the reverse disclosure law and the changes to, essentially what you were talking about earlier. What are the changes to the law, and how will they affect the rights of the accused going forward?
Well, when I first met Joseph, and then we started working together, it was because he was the first defense lawyer to say anything about these proposed new changes when Bill C-51 came out that had all of this, included in it. And he said, "This is catastrophic." And I'm like, whoa, I did like fly in thug life sunglasses on a video featuring him. And so we fought against it. And, the reason that there was no, we call it reverse disclosure, the Crown has to disclose everything in their possession that, as part of the investigation. And they don't have an obligation to investigate, just because some people get confused about that. Just because somebody says something happened at a restaurant or in the lobby of a hotel, the police do not have to go and get the video. They don't have to interview everybody who's mentioned. So, but the stuff that does come across their path, and that includes, emails from the complainant or anything else that's sent into them, anything that's a product of the investigation, has to be turned over to the defense. This is what I was mentioning earlier, why it takes so long for us to get the full disclosure, because it comes in waves. So it's not just one set of disclosure. We might have like 3, sometimes 10, depending on the size of the case. Complainants can go back and make another statement, and then they have to disclose that, and we have to get it transcribed. There's a whole bunch of stuff that goes on. But the reason that the defense doesn't have to disclose in reverse is because you cannot be compelled to assist in your own prosecution. So if the defense has to turn over evidence in their possession, then you're potentially assisting in your own prosecution. And also, because you've got the limited resources of an individual going up against the unlimited resources of the state. So it's an effort to level the playing field. So I would say, since we've experienced these new disclosure regimes, this means we have to bring a pretrial application in order to get permission to use things in our possession. Things in our possession is the actual word in the legislation is a record. That then there is a big dispute about what's a record. So if you have a financial transaction from your bank showing that money was transferred from one place to another, is that a record? Because the word record has a definition in section 271 for other reasons. And it has to be something with a reasonable expectation of privacy for the complainant. Does the complainant have a reasonable expectation of privacy in your bank records? Is there an expectation of privacy in photographs that were taken of you out in public on a trip, where the person's aware the photo's being taken, they're out in public? There's not really any expectation of privacy and things like that. But at the beginning, everything, it was scorched earth, everything had to be put into the application. And if you go to trial and you want to decide you want to use something and it wasn't in the application, well, you might have to have a mid-trial application to find out if you can use it. But the first question is it a record? If it's not, then you don't need permission. And essentially what you're doing is, and every application has to be supported by an affidavit, which generally is going to be an affidavit of the accused person, because the affidavit has to be by somebody who can either or say these things are true documents, these are the things that we expect are going to be said in court. And sometimes, if it's not a document, if it's a line of questioning that we want to engage in that has to do with something and what is of a sexual nature, that's another change. It wasn't just prior sexual history or other sexual history. It's now anything of a sexual nature. So this can, for some judges, include flirting, right? Not even kissing, but somebody flirting with you. Oh, you didn't put that into your application. You're not allowed to question her about whether she was flirting with him at the bar, right? So, or prior, if it's separated by even an hour, they'll say it's other sexual history, something of a sexual nature that's other sexual history. So what we do is we prepare for everything to be questioned. And we look at it as an opportunity now, because we've been very successful with these applications. There's a form you can fill out for the application. We don't do a form, we do a full factum. Essentially, that's like part of the application. And we lay out in full, good or bad, what the allegations are. We'll lay out, things that are confusing about the allegations. That's the background, that's including what they're charged with. And then we go into anticipated evidence of, and this is a big thing that Joseph and I have railed about on our podcast. We go into anticipated evidence of what we expect the accused person is going to testify to, because their testimony is just as valuable as a complainant's testimony. And people forget this. We'll go into these applications sometimes, they say, well, it doesn't matter that he's saying this because she said that, therefore there's no air of reality. Like, I'm sorry, that's an issue for trial, right? When you go into these pretrial applications, the testimony that we expect from our client is given full weight. It's, they're supposed to assume that what he's saying could be true, and therefore is this line of questioning probative of an issue? Because even if she didn't bring it up, if he's going to mention it, we need approval, right? So these are all important things to get clear so that you're not interrupted when you go to trial. But it's very similar in the end. We found there's a thing that we call an RPC package, and you'll have to help me out because I do talk more like a lawyer now than I used to. But RPC is a reasonable prospect of conviction. And in some cases, we've put together packages just for the Crown's eyes without prejudice to say, do you really think that you want to take this case to court? These are the things that you can expect to see if you take this to trial. And you should really reconsider whether or not it's in the public interest to prosecute. And sometimes even say, this complainant is gonna be blown out of the water. Do you really think that it's worth having her come up and testify just so she can be shown to be a liar? You know, and so it gives them a chance to really reconsider, and it's good for the client and it's good for the public if the prosecutors really look at these things and take them seriously. Unfortunately, they often don't even read them for months when we send them in. But these applications that we do with documents and all this stuff, it's another form, it's an even more intense form of doing an RPC package, where it gives, and we have had a number of cases where the Crown has said that they're withdrawing the charges after we won our application. So it's ended up being not bad for us.
Okay, so that leads into, I guess, my last question before we open up questions to the group. It sounds like an RPC package might be the opposite of someone taking a plea deal from Crown Counsel. And I know that potentially 75%, or sorry, I think 90 or 95% of cases are resolved by plea. And if if everyone took their cases to court, it would overwhelm the court system, and I think the court system would likely crumble. But I'm just looking online here about the duty of the Crown. So the duty has or the Crown has a duty to be fair and maintain public confidence, to has an additional duty to ensure that the justice system operates fairly for all, which means for both the accused and the accuser. So a moment ago, you said the police don't have any duty to investigate and do research on other witnesses who might have been there, and I've heard before that the Crown will say that their obligation is to investigate the complaint and not the complainant. But it seems that there's maybe something that's not doesn't quite line up there, because if they're not investigating the complainant, then they're not ensuring that the justice system operates fairly for all. Do you have any thoughts on that?
Well, the obligation, it's a special obligation of the prosecutor, is to seek the truth, not to seek conviction. And so they're not supposed to be the complainant's lawyer. They're there to represent the interests of the state, to determine whether or not a crime took place. If they don't believe a crime took place, they're not supposed to prosecute. But that doesn't necessarily always play out, especially if you have a junior prosecutor, because we've had cases where they need to get permission to withdraw charges. Now, it's not a plea deal, but quite a few cases end up being resolved with a peace bond, where they withdraw the charges. So you're not pleading to anything. They withdraw the charges if you take a peace bond. And this can be distressing for a lot of people, and it's a policy. It's very rare that they'll just straight withdraw charges. So it means that you're not, the charges are withdrawn, you're not guilty of anything, but you do have a peace bond that can show up on a record search. And so that's disturbing to some people. And it can be taken as, oh, well, they withdrew the charges, but only because he agreed to a peace bond or something. So people can, complainant can try and represent that they were still vindicated, like they were still found to be guilty, even though it's not true. So the peace bond is a big struggle for people, but a peace bond is a really good thing. If you don't have to go to trial, you go to trial, you always take the risk of, things going off the rail and somehow getting convicted. You have a chance to stay out of court, always stay out of court. And, the peace bond, you can revisit and ask to have something removed from your record after a certain amount of time, especially if you have compelling statements made by a judge. But a peace bond is a really common thing, as long as it's a common law peace bond. And that's the only way to have the charges resolved in most cases. They can't just simply withdraw charges. And sometimes, unfortunately, prosecutors do not like their case, but they will go all the way to trial because they need permission to withdraw. So we always tell people, no matter how ridiculous the allegation is, no matter how good your evidence is, always prepare to go to trial.
Okay, that's the end of the questions for me. We've got a couple of other, so thanks very much, Sarah, for putting your hand up. I got a couple of questions that are in the chat right now. One, can you move to quash an outstanding failure to appear bench warrant before the accused has turned himself or herself in?
I feel like that's too much of a legal question that I'm not qualified to answer.
Okay, fair enough. Um, Sarah, do you want to ask your question verbally, or do you want me to ask it for you?
I have a different question and comment than what I put into the chat at the time that she was talking.
Okay, go.
Um, my name is Sarah Nicholson and I'm in Alberta. I got involved by helping one father, then another father, then a mother. And then I got involved. We went through a long process, learned a lot about the corruption that goes on. For example, the people that are doing the PN7s meet regularly with the lawyers. There's all kinds of little tricks that they use. Some of them are hiring guns. We've worked around that stuff. And of course, false accusations used. But I ended up, because this was so difficult, getting involved politically. So I got involved with the UCP, which is Danielle Smith's party here in Alberta.
Oh, I love Danielle. I've been on her show before.
Have you?
Yeah.
So I did 27 policy resolutions for the AGM, and there's going to be another special general meeting where some of the rest of my policies will be put forward, and I'm meeting about that right now. And we are trying to address through that, and it isn't binding, by the way, when it goes through the AGM, but the party has to pursue it. So we're trying to get rid of the RCMP here in the province. We're trying to trying to get rid of child family services and some of the corrupt stuff that's going on in the hospitals, because the child family services is advising mothers to take the tactics that you've discussed here. And also we're trying to deal with parental alienation in that. Lots of things. One of my proposals is to automatic 50-50 parenting between mother and father, unless there's a history of abuse, because of course that's the first thing they scream the minute that they are in the process of trying to get their kids. But I'd like to make you aware of something and then ask you a question. So we got the mayor of this city involved because there was so many issues with the RCMP here. I had provided myself a 40-page report to the RCMP showing clearly that a child was being abused by a mother who the hospital even suspected of Munchausen by proxy, but has full custody of the child because the father started this whole thing by reporting a pedophile ring involving the Jehovah Witnesses. And we later found out the CFS, he's even got a threatening letter, and the RCMP. So the minister here, who was from the previous government, as soon as we had that request for an ACERT investigation put in by that mayor and CAOs and council, the minister here swept in and booted the entire council, in my opinion, illegally, because he was also being investigated by that council because he was brother-in-law to the previous mayor, and there were some connections to the stuff in Coots, etc. So when all of that happened, and it's just happened recently, and I am talking to some people on the inside about it. But hi Vlad. What ended up happening was that we're in the situation right now where that mayor's trying to get an injunction, and I'm trying to appeal to some people on the inside. But we have not had any investigation done by ACER, and we know that the people that went in power are corrupt that went into the municipality. And but the application was made by the mayor, like it already went in with all the documentation to ACER by the previous mayor. So, you know, we're getting the runaround. Dale's doing that with me, Dale Richardson, who you see here. We're getting the runaround, and so far there's no sign of an ACERT investigation. And so I'd like to know if there's anything that we can do in order to force that ACERT investigation, because it isn't just about parenting issues. It's about cross-border crime. And we had a lady in this city who was beaten up by someone here, and her mother, she was a kid when she was 19, and her mother went to the mayor, who went to the very dirty staff sergeant. And oh, I'm being asked what ACERT is. ACERT is where the RCMP does an investigation of itself. It's the only kind of investigation that you can get for corruption. There is no independent body. Something else that I've asked for, by the way, in my policy requests. But anyways, so I want to know if there's anything that I can do, because I think they've called off that ACERT investigation, even though the previous mayor did it, and there's plenty of evidence of corruption in this city.
Sorry, Sarah, I'm just gonna interrupt you for a second. Do you have a question for Diana?
That was it.
Yeah, I've made a few notes on things that you said that I can comment on. First of all, the 50-50 thing policy that you're talking about is called the Swedish model, because that's in Sweden, that is the default, is the 50-50. It's called the Swedish model. And there's a guy who was he used to work at EBC. He's written some really great books on because he himself was alienated from his children. I'll see if I can remember his name. I haven't talked to him in ages. He took a sabbatical because everybody at EBC hated him. But anyway, so RCMP, switching from RCMP, I think is a good idea. I've been in contact with officers from all over the place who encouraged me to keep doing what I'm doing. RCMP have particularly said they're embarrassed to be RCMP now. And so there's more and more movements to try and get local police instead of RCMP. What you were describing in the end sounds kind of like a John Grisham novel, to tell you the truth. It sounds pretty crazy. There's a lot of stuff going on in there. But I did have some experience with the RCMP and ACER when I was helping my very first lighthouse client. Actually, he was in Red Deer. And he was made to go to 2 different trials because she made an allegation from the time she called the police, and then she went back and made historic allegations. So he had to go to 2 separate trials. He got acquitted at both. In the second one, where I was able to attend in person, the prosecutor ended up recommending that he be acquitted because when she saw the evidence that we had, she actually recommended acquittal. And that's what I mean. Some prosecutors are really good. But we then went back to the police to make a complaint about her. And we had all this evidence that she lied. The police had 0 time for this complaint, and they almost threatened. I was recording everything too. They pretty much threatened that he might get charged again if he tries to force them to take any action. Then one of the allegations against him was that she had gone to his house when she didn't live with him. She had gone to his house because they had a fight earlier. And then she said something about, oh, I remembered that I was supposed to give him a dress that his mom was going to fix for me. So she goes over to his house at like about 10 p.m., lets herself into his house. He's like, and then she's calling to him. And he's like, get out of my house. Get out of my house. And instead of getting out, she took her clothes off, got into bed with him. And then she says he ended up assaulting her. And so this was her story to the police. And they go, well, and they did at the time say, well, did you live there? No. Did you pay rent? No. But I had a key. And the officer goes, oh, okay. So when we're talking to them about all of these things that show that he was actually the victim of a sexual assault, we didn't just want to have her charged with making a false report. We wanted her charged with sexual assault for that particular night. And the officer goes, well, what do you expect us to do? And I said, well, I expect you to, at the very least, tell somebody that when they go into somebody else's home and they're told to leave, they have an obligation to leave. I would expect for you to advise them of the law on that. And they go, okay, fair enough. But in the end, we couldn't get anything. And we put in requests because they said, well, you should get, you should get information from them about all your file and all this other stuff. So we put in requests through ACER. It took 1.5 years. He had to follow up, and they said, oh, what's your number, your file number? I helped him find the file number. They had nothing. They said, oh, yeah, well, no, we just kind of closed that. They give us nothing. It's completely useless.
But the question was, is there anything we can do about forcing that ACERT investigation since it was already initiated?
I don't think so. I think all you can do is, from my experience, all you can do, because you're in a better position than I was, you're talking to politicians, which, by the way, I'll warn you, they'll always say that they agree with you and they think what you're doing is great. But then when it comes time to vote, they don't do anything because they don't want to be seen as anti-woman.
Oh, I've already experienced lots of issues. It depends who you talk to, but even the good guys are afraid.
We keep fighting, right? But Donald Dutton, Dr. Donald Dutton, he's done amazing work on domestic violence and showing how it's reciprocal. And when it's, it's more likely to be the woman who's the aggressor when it's only one directional. He's done amazing work, done presentations at the Senate. They all applaud him. They give up their speaking time so they can continue on. And then what do? They continue voting exactly the way they voted before. So I don't want to give you false hope, but at the same time, we got to keep fighting. And it sounds like you've got some good ideas. So I would say just keep pressing forward, and RCMP, trying to get local police instead of RCMP. According to the RCMP who talked to me, that's a really good idea.
Yeah, they're pulling a little bit of a scam here. We have a dirty Minister of Justice, and he's handing every municipality $30,000, which I'm a former CBC reporter, by the way. So I'll just tell you that it's a scam, because the 30 grand that they're giving to each municipality is to kill time, so they don't have to do anything, because on the previous, it was already in resolutions to get rid of RCMP when we were under Kenny. That never happened. This has been going on for a long time, and the Ellis is blocking a lot of stuff that would help fathers and children and stop child trafficking. And we can prove this, but there's a lot going on in Alberta besides that, and it's a big ship for Smith to turn around. But this is what got me involved in the first place. So
I guess the only advice would be is just try and keep it simple so that people don't feel like they're getting caught up like in the John Grisham novel. Just try and keep your goals simple and put them in steps. But there was, just as a final thing to do with Alberta, I know there was a successful event there where they took research to the police department in Edmonton, and they forced them to give the information through freedom of information requests about what their policies were, and then they showed them how their policies were based on false data and false models of domestic violence, and they made the police change their arrest policies. So there is some stuff you can do through freedom of information, I guess, but ACER is kind of the freedom of information thing.
are you working with Carrie Simpson?
Sorry, sorry, Sarah. We've got a ton of questions in the chat. I just want to make sure that we're
I
respecting.
know, Carrie.
Diana, are you working with Carrie? If not, I'll give you the information.
I have talked to her, yeah.
Okay.
Thanks so much, Sarah. Diana, next question up in the chat. It was mentioned that in discovery and family court, or the discovery and family court can be used to assist in a criminal trial. Does it work the other way around? Can statements to the police that were made in a criminal investigation be used in family or civil court? Are you able to comment on that?
Yeah, that's why I said sometimes there's a little bit of a delay in which we can't get to court, in one venue or the other, because we have to coordinate like that. That's why it's important that your family lawyer is able to work with the criminal lawyer. There are some limitations. We can't give video evidence of a statement to anybody. And, in fact, the clients have to come to the office because of the undertaking that we have, but the transcripts can be shared with some limitations on it. So that's just a discussion depending on the nature of the allegations and what the details are specific to your case. They should just work together and try to coordinate. Sometimes you can't put off family court. Some family court things have to happen before the criminal trial, but but sometimes there's a reason to delay. Yes, we have made material available to family court lawyers and also a civil lawyer, because the complainant was suing the accused in civil court for money that she claimed was owed to her. So we did share information back and forth with each other. The better the relationship between the criminal lawyer and the family lawyer, the easier it is to share.
Okay. Next question came up. Based on the changes in jury selection, is it more favorable? I know this is kind of an open question. Is it more favorable now to have a jury trial or a judge alone trial in your experience? That's
a decision that that only the accused person can make. We can give advice on what we think is best for you, given the case. Sometimes the details may not sit well with a jury, but sometimes a jury might be better because judges get too technical, and so you want to have people use their common sense. Common sense is frowned upon by judges, but it's encouraged in juries. So it's really case specific, and it's actually a complete conversation to be had. That's another thing, going back to Gavin's question about when you should be concerned with a lawyer. If a lawyer is making elections without having a proper discussion with you, then that's definitely, so if a lawyer just says, oh, I've elected to go this way, that's a conversation they need to have with you so that you understand whether you're going to go in a lower court, the provincial court, Supreme Court, or depending what province you're in, sometimes they call it the Supreme Court of BC or whatever, but it's Superior Court. And whether you want a jury or not, it's something you should participate in, because only the accused person ultimately can make that decision. And that is the same thing, this is important to mention, about whether or not you testify. That's a serious decision to be made. And I'll tell you, if it's a sexual assault allegation, we've said it over and over on our podcast with Joseph, you know, if you don't testify, there's only she said, there's no he said, right? So, you know, to not testify, unless there's an extreme reason, to not testify in your own defense in a sexual assault allegation is a very strange choice, put it that way.
Great. Last question from the chat, and then I'll move to Trevor. This is, I guess, an opinion question. In your opinion, do you believe that when a female makes a false allegation, or women that make a false allegation are mentally disturbed, that they actually believe the allegations took place? And if so, what percentage of women that make false allegations are that disturbed? That's the question. I'm not sure how to.
Well, I mean, it is fascinating. That's one of the things when I started doing this, is like, I'm fascinated with why people lie and how they craft their lies. And, you know, usually people will take something, they'll start out with something that really happened, and then they embellish, exaggerate, or reverse what took place. But there have been some really interesting studies. I did a video on it, set to clog dancers, because it was done by a Dutch researcher. Why Women Lie About Rape, I think it's called. But anyways, there's the guy's last name, I was trying to figure out if I can search for it, is Dezutter, D-E space Z-U-T-T-E-R. And he's done two interesting studies. One is looking into the reasons that people lie about sexual assault or rape. And they went with reports from the police where they had confessions of people who admitted they lied. So that's what they were looking at specifically. And then they looked at the reasons why the person said they lied. The top reason is actually alibi. Mental illness is one of the categories, but you know, and what do you call mental illness? I mean, we're so, everybody's on medication for something, it seems nowadays. But the top reason is alibi, and alibi means they're in trouble for some reason. They failed an exam, they're failing school, they weren't showing up for work, they got caught cheating, and so then they need to say, so alibi can be just getting yourself out of trouble for anything, right? So that's one reason. Revenge, people think is really high on the list, but it's somewhere lower down, like around 5. And but it's a fascinating study. The second top reason that people lie about rape is they don't even know. They don't know what came over them. They actually they can't figure out their own motive. And that's why it's a forbidden question in court to ask an accused person, why would they lie if you didn't do this? You're not permitted to ask an accused person why that person would lie, because it subtly changes the burden of proof. Now you have to come up with a motive. And the reality, to defend yourself, the reality is the top second reason is they don't even know. You can't really know why somebody's lying. And, you know, what do you call mental illness? They were depressed, right? You know, a lot of people now are considered, what do they call, bipolar? They call it something else. You know, is more and more diagnosed, where, you know, and especially if there's alcohol involved, which in a lot of sexual allegations outside of, you know, long-term relationships, there is alcohol involved. So people do things that they then get embarrassed about. This is interesting, actually. I had a theory that that especially young people, university students, they go out, they're not at home for sometimes the first time in their life, living on their own. They get a little out of control, they drink too much, but they're also in an environment where there's a lot of gossip, especially, you know, young women. So they go off and they end up having sex with somebody, and then they later think, oh my God, I don't want anybody to know this happened. And so they come up with to get ahead of the story. Or if something embarrassing happened during the sexual encounter, to get ahead of the story, they come up with this allegation, oh, it wasn't my fault, they raped me. And since having said that, we actually had some young people contact us, young women contact us and say, you're absolutely right. That is a big problem. You wouldn't believe how many people tell me they were sexually assaulted when all they did was get drunk and make a stupid decision. But there is a study on false allegations, and mental illness is extremely low on it, like legitimate mental illness where like schizophrenics or something like that. Well, what do you, well, let me turn it back. What do you mean by mental illness though? Is there ability to answer, or is this?
It's just a question that was posted in the chat. So,
Oh, right. So
it
there's no one
could be
actually.
borderline personality disorder, could be narcissistic personality disorder, any of the type B personality disorders, I think is what they're referring to.
Yeah, but narcissistic personality disorder is like very rarely diagnosed. They're pretty much impossible to treat. If they ever go see a psychiatrist, they just play head games with them because they think they're so smart. So I don't know. You can find somebody to be narcissistic, but I don't know if you could actually call it a mental illness because they'd have to be diagnosed. And also, that's another point to make too, that even if there was a mental illness like bipolar, schizophrenia, even, it's extremely difficult to use that in your defense in criminal court because if it was to be held against their credibility that they have a mental illness, it would make people with mental illnesses unrapeable. That if, it's like, oh, well, they got a mental illness and nobody's ever going to believe them, right? That's why it's not permitted. So it's extremely rare to be able to bring up anything to do with a mental illness unless the complainant makes it a factor. And there's also a circumstance that has come across too, where they said that she went into a state of despair that was consistent with her mental illness. So we're saying, well, this wasn't just because this thing happened to you. This is a state you go into quite often. And she even said that she quite often gets into that emotional state late at night for no particular reason. So sometimes it can become relevant, but it's almost never permissible in terms of cross-examination.
Okay, so just a quick note, two things. One, I'm going to post a video in the chat. It's called Regret is Not Rape, and it deals with a lot of the reasons that were put forward by Andre de Zutter. Also references the Susan Brown Miller quote of 2%. Really looks at different analysis of the reasons for false allegations. So I'll put that in the chat now. And then Chris also mentioned there is a book that was produced and sold on Amazon called How to Destroy a Man Now, DAMN. It's been pulled from Amazon because it was so misandrist. But we were able to find it in I can't remember where I think archive.org had a copy of it. So we pulled it and made it into an audiobook. And it's kind of a warning for boys and men because this person, her name is Angela Confidential. She goes under a pseudonym, but Angela Confidential really lays out a roadmap for how to take someone down with a false allegation. So I'll just put that in the chat as well, and you can.
Well, as a note, when I was 16 years old, I had a woman who's about 10 years older than me say, I'll tell you exactly how to leave a man. You wait until they go to work, you have a moving truck pull up, all you have to do is leave them one fork, one spoon, one knife. And she'd done this like at least 2, I think maybe 3 times. And she was giving me advice on how to do it. And I was just like, that's disgusting. But no, it's like, if that came across and there's a book out there, women share this stuff. They talk about this stuff with each other.
So just post those in the chat. Thank you very much for that recommendation, Chris. Dale, you're the next question. Go ahead, man.
Yeah.
Sorry, does that make it premeditative with the line of where you're talking? So you can go to culpability and further.
Sorry, what's the question?
Yeah, I guess, sorry, James, we'll get to that in just 1 second. Dale, go ahead, man.
Yeah, I just had a couple of comments first before the question. One, like, because I deal with a lot of human trafficking victims and so forth, it's not very difficult to tell when a woman's telling the truth when she's traumatized about an event. So a lot of the times the police officers are actually not doing the job. A lot of the times they come and they grab them and ask the wrong questions so that the woman can't relate the information when she's actually traumatized, and then they take people who are lying and push them into court. And there's a large disconnect between what the police officer does and when it goes to the crown. And when you have somebody who's, say, for example, being raped and they're being ignored by the police officer, then you get the liability of them violating other laws, like, for example, 269.1, because when they allow crimes to happen that cause people psychological duress, they're actually torturing them. And then there is recourse for that, and they do have a duty to investigate. And sexual assault's actually used quite often on victims who are actually being assaulted by the police ignoring them. And then everybody else in that chain that ignores them are also liable based on the laws, because there's subsection 4 has a no defense clause, which is never utilized in Canada at all. And it's one of the grossest forms of torture. The other thing is that um, is there any action where they actually use to your knowledge, the torture laws in Canada? Because I mean, this happens, I see it happening frequently. It is employed almost universally in Canada, and I have seen no prosecution for this. So do you have any idea of it ever being used in any criminal cases?
I mean, I'm not as experienced as Joseph or something like that. Certainly there hasn't been any cases I've worked on with torture. Human trafficking has its it has a specialty division that looks into those cases. They have sting operations they do where they run stuff through the computer with phone numbers on things like Backpage, which I think is gone now, but there's other sites that have taken over. So they have it search for repeating phone numbers, and then they'll start looking, and doing full-blown 2-year-long or more investigations to try and catch people who are trafficking and forcing people into prostitution. So they do like intense investigations into that, and but then we had a case where somebody needed to get from Toronto up to Thunder Bay, and she couldn't afford, and her mother couldn't afford to fly her back or send her home, so she made an allegation she was being trafficked, and they just hashtag believed everything, and they tried to get her to make a statement. She only agreed to make a statement because she said her mom agreed to give her a hair straightener if she made a police statement. So that's an interesting thing, because like you're talking about like real victims, and that's one of the things that makes me so passionate about dealing with false allegations, is that it is such a dishonor to real victims when people lie about it. And there needs to be more anger from feminists about people who actually lie about this, because it undermines the real experience of what it's like to go through that, and it takes away from our ability to believe women at face value, because despite what you hear, because unfortunately the media is mostly controlled by activists, but there's a lot of people out there, especially now that Twitter is x.com, there's a lot of people out there who are sharing their experiences and spreading awareness. The Innocence Project has done amazing work. Like Gavin said, there has to be some sort of DNA thing, and unfortunately Innocence Project is getting a little more social justice now. So but these he said she said cases, things that are really come down to technicalities about how the trial was conducted, they have zero interest in that. And but there is a new post-conviction review committee that's being established in Canada right now that will allow people who've lost their appeals, and sometimes losing the appeal means you just weren't granted one, that there's another method to try and vindicate yourself that's becoming more available. And there's an amazing lawyer in Alberta named Peter Sankoff, who's done a lot of appellate work in Supreme Court. I will get back to your question. He's done a lot of appellate work in Supreme Court and appeal work in Alberta, and he's trying to mobilize and use this new legislation, which I think was spearheaded by another great lawyer named James Lockyer, who does a lot of wrongful conviction cases. But in terms of human trafficking, I don't really know what I can say about that. Torture laws, no. They've added some strange charges to one of the cases that we've in. They added, they tried to say that there's that any consent that the person had was vitiated because of authority and control.
For which,
So, you know, originally this guy was charged with trafficking, and then it became clear that he wasn't trafficking, but he did have sex with the girl who was doing sex work on the side. And then they tried to say that she couldn't have consented because he had a position of authority. And there's no evidence of position of authority, but they try to get as many charges laid as possible. But no, I haven't seen anything to do with torture. When you mentioned torture, actually, what I was thinking of is the interrogation techniques. We've had cases where an accused person said they didn't want to give a statement, and they were asked to give a statement like 14 times. They said, no, I don't want to talk to you. No, I don't want to talk to you. And the statement they ended up giving when they were exhausted and they just felt that saying no wasn't going to make a difference. After 14
that's
times,
torture. That's straight up
that's
torture.
torture. And
Well,
that statement was deemed to be legitimate, even though he said no 14 times.
Yes, actually, law enforcement employ torture in Canada frequently when they have an adult interrogating a minor, which is lawful in Canada. That's a violation of the torture convention. It happens all the time. They torture people routinely, and this is where we have fundamental errors in the way that we deal with things, because when you're allowing crimes to occur to get convictions, then you have problems. And just yeah, I think that there needs to be some changes. The next thing, one final question here that comes in here, and this is where I see a lot of problems when I look at some criminal cases, is why is application to, for example, the criminal law and the charter not applied as much in those cases where they begin to use case law? Because when I see case law has its place, but a lot of the times I see a lot of bad decisions being strung together where it completely negates the law and also negates the charter at the same time. Why are we seeing so much heavily dependence, especially even in criminal trials, on case law rather than the interpretation of the law in light of the charter, and then testing that case law to see if it's the right decision? Because then it takes away, when they do that, it negates the due process.
Yeah. Okay, well, you said a couple of things. One, case law. It's interesting when you look through case law, you can find a case to support pretty much any position. So there's no uniformity. And if you go through Canley, you can find something to support, as we do argue, you know, at the end in closing submissions, we'll have cases that support one interpretation of you know, rights or, you know, assessment of evidence. And then the Crown will have the complete opposite case law. It really comes down to trying to find the most recent and the highest level court in order to have your side of the case law taken seriously. But the charter, this is very important. The charter has a thing called Section 1. Section 1 allows them to violate your rights if it's in the public interest. So Section 1 allows them to not actually, you know, give you the rights that are guaranteed under the charter. There's another Section 33. There's a few things that Women's Legal Education and Action Fund fought really hard to build into the charter, especially under Section 15, which is the equality rights. But there's another thing too. A friend of mine, he had a nonprofit he started up fighting for, there's two different ways of interpreting law. One is the originalist. So you take it at face value and you take it with the intent of the people who wrote it. And the other is called the living tree doctrine, in which the law and the interpretation of the law, because the law can say the exact same thing, be interpreted any way they want to. And this is what they do with case law, that interveners will go into court and change the way the law is interpreted in order to change what the law means. Right? So it gets very confusing about what words mean. And in law, when you get to Supreme Court is philosophical. Their job is to answer intriguing philosophical questions, which is why they only take on a certain number of cases. They only take on the cases that they find philosophically intriguing, unless there's a right of appeal, in which case they have to hear it, right? But the living tree doctrine allows them to interpret things in any way they want, and if all else fails, they have section 1. And there's another thing that happens too when somebody's successful in an appeal. They can say that it's not in the interest of justice to grant the retrial anyway. That they can say that it's, the conviction would have stood on other grounds, even if you can argue successfully one ground of appeal. They say, but there were other things too. So they use this doctrine where they can just say that they're going to uphold the conviction anyway. So when people go into court thinking that there's a charter, I'm a human being, I have human rights. Well, it's kind of shocking sometimes to find out that they don't apply whenever it's not convenient for the public interest.
Just one quick thing before I just wanted to respond to what you said there about the charter. There are a couple of things that people need to also make sure, because first of all, section 1, it shouldn't be there, but regardless of whatever you say, when you look at section 7 and section 12, and then you have to take into consideration, for example, the Torture Convention, which is not limited by the charter. It stands on its own, and it's an international instrument that's binding on Canada. It has the same force of the charter, but it has unalienable rights in there. So now, if you violate section 12, which is cruel and unusual punishment, then you've just automatically triggered the Convention Against Torture, which does not have any section 1 capability to be limited in any way. It was designed to protect people from exactly the same thing when you have under section 1 saying, well, it's in the public interest to torture you because we don't like you. That's unreasonable, right? Because that's how tyranny begins, is through torture. So now when you have somebody, for example, in prison unjustly, you've now triggered section 12 and the Convention Against Torture. These are things that should be used. And anybody to sit down and say that they can have somebody rob them or kill them unjustly and have a section 1 violation is out of their skull, because that's allowing that's unreasonable. That's not a free and democratic society. So I think that more of these types of things should be used in these situations, because ultimately section 1 is being used to justify outright criminal activity, and it should not be, and it should be restrained, and they have legislation to do so. Just kind of lay that there.
Yeah, the cruel and unusual punishment, when I've come across that as a successful argument in court, it has been used in appeals, and that's mostly to argue against mandatory minimum sentences or the SOIRA registry. SOIRA is the sex offender registry that some people were put on it for life. That's now been deemed to be unconstitutional as cruel and unusual punishment, and the mandatory application of they had to go and rewrite it. There's essentially here's one of the problems when something's found to be unconstitutional and gets thrown out by Supreme Court. Parliament will go and rewrite it, and they'll pretty much do the same thing, but they use slightly different wording, and then they say it's a new law, and then it'll take another 10 years before somebody successfully challenges it again. It's kind of sick, but that's the way it is. And so, and then the other thing too is like, what do you call torture? It's like there's a lot of things that are torturous when you're experiencing them, but then the question is, does it amount to torture in the eyes of the people who are engaging in it? So it's a tough battle, but just know the answer to the question is I haven't seen torture used as a charge against anybody, and having police charged with cruel and unusual punishment is extremely difficult. They're given a lot of leeway. They're usually only prosecuted if it amounts to a death taking place. Then there's a full investigation into the excessive use of force, but they don't call it torture, they call it excessive use of force.
But when somebody complains, they're supposed to investigate, otherwise they break the law. And that's where you're seeing the ball dropped on that, because they do have an obligation to do so. It's written in the law, and they never do it. And how do you address that?
Well, I think the only thing you can really do is just create visibility where you present, and there's a lot of people who do this too, like just to prevent videos of people, even if they're in shadow or something like that, and if their voice is altered. Can you talk about, their experience of torture and how nothing was done about it, and just try and make it as visible as possible. That's really all I can say.
Awesome. Thanks very much for the questions, Dale. Vlad, you're up next. And then John's coming on after that.
Good day, Diana. How are you today?
Hi, I'm doing good. How are you?
One day at a time. I apologize I jumped on later. I'll definitely watch the replay of the first hour almost that I missed. I don't know if you're familiar with my story at all. I was one of the original organizers for anti-government protests in spring of 2020 regarding COVID measures, etc. I'm not sure about your viewpoints on that. But the main aspect of my discussion is that my ex used that narrative to get rid of me, to strip of all my parental rights. I was a second parent in the country, to lose all my parental rights simply because I was opposing the narrative and I was organizing the protest. It's literally part of the endorsement that the judge rendered, Justice Akbarali in Ontario, back in July of 2020. And they used the ruling of Justice Pazarat from March of 2020, which was the first ruling in Canada during COVID narrative for the parent to lose all parental rights because of that. Are you familiar with those rulings at all, or?
No, I missed a little bit, just sorry, because you were speaking kind of fast with an accent, so I missed a little bit
Yes.
about it. But I think I caught you were involved in a protest to do with the pandemic.
Correct. I was one of the original organizers in Toronto and Queen's Park since
Oh,
April of 2020.
BJ
Huh?
Dictor. BJ Dictor?
Of course, I spoke
Yeah,
with him at
he's
the
a friend
Queen's
of
Park
mine.
multiple times. Yeah, so I started Hugs Over Masks. That was me, and then multiple other initiatives and movements. And I'll slow down my speech. Yes, I know I'm Russian and I speak fast because I am Russian. So that's why I'm always Russian. That's a joke anyway.
Okay, we walk
Uh,
fast in Toronto.
Yeah, so I'll repeat that I was the second parent in Canada to lose all my parental rights simply because I was organizing the protest. It was literally part of the endorsement rendered by the Justice Akbarali back in July of 2020. And the ruling as a precedent they used was back in March of 2020 from Justice Pazarat. And that was the first ruling in whole Canada regarding parental rights strictly because of the COVID narrative opposition. Okay. Now, the reason why I bring that up, even Justice Pazarat ruling, which was the first in country of Canada, is because he actually had changed of heart, where he changed judicial. I always forget the term. What do you call that when they take opinions as factual information?
Judicial notice?
Huh?
Judicial notice?
Correct. Yes. So he had a ruling around trucker convoy period. So in 22, in the winter of 22, where he actually stated that the government narrative regarding the COVID cannot be taken as a judicial notice anymore. So it was interesting that the judge that ruled it one way was the first judge to rule one way in 2020, actually had changed of heart almost 2 years later to the date. But long story short,
Well, the information about the virus was changing over those 2 years too.
well, it's a whole other discussion we're not going to get into. I'm sure there's a time-sensitive amount here, but what I'm getting to is I understand you specialize more in false allegations regarding the rape, etc. But are you also a little bit specializing or looking to specialize into false allegation that leads to fathers specifically to be stripped of parental rights?
Well, I haven't, unfortunately, I can't get too involved in family court cases because they're endless. They'll go on for a decade or more. And the resources are just, I just don't have, there's lots of groups that specialize in parental alienation.
The reason why I ask is because my case did cross over into criminal level. So my ex, because she couldn't handle me exposing her on Facebook, she filed criminal harassment charges against me for making Facebook posts on my own platform that she doesn't even follow. Okay. And the Toronto police did charge me, arrest me. I had to get a lawyer for bail hearing, and that all happened in August of 22.
So I have a very extreme interest in things that happened around the pandemic and people who were charged. One, BJ Dichter is a very, very good friend of mine. We were actually just out on Friday night after we did a podcast. And
He knows me well. As soon as you tell him about me, he'll know me. Yes.
Yeah. But also I had an adverse reaction to the vaccine when I was, I can't really say forced to, but I
I'm
was
sorry to hear.
heavily pressured into getting the vaccine. So I was
Most
on
people.
global
most
news
people.
talking about my reaction, and I was horribly treated by doctors who refused to admit it had anything to do with vaccine. So I followed all of this obsessively for years.
Okay.
And I was really stoked. Unfortunately, most of the cases to do with the pandemic have not been successful.
Yes.
But I can tell you, especially because you're in Toronto, there's a lawyer named Lisa Bildy.
Okay.
Lisa Bildy. She used to work for the JCCF, that's the Justice Center for
Yes,
Constitutional
I know
Freedoms.
JCCF. Yes.
They went off the rails a little bit.
Yes,
But
they have.
yeah. And
What's the last name, sir? Lisa?
so her name's Lisa, Lisa,
Yeah.
and Bildy, Bildy. She was specializing in helping people with cases related to the pandemic. She'd be, and she's a very generous person. I'm sure that she would make time to talk to you. Just mention that you know me.
Sure.
And
is she criminal lawyer, civil lawyer, or?
no, she's a civil lawyer.
Okay.
And but she's really well connected, and she's
Okay.
done a lot of work with Bruce Party and with Freedom of
Yes, I know Bruce very well too. Yes.
Yeah, he's
All the
amazing. I haven't
circles.
talked to him in ages, but yeah, I mean,
Well, he was in Ottawa. We were part of the same small group of people hanging out in a hotel in Ottawa during the Tucker convoy. So I spent a lot of time with him.
good for you. That trucker convoy that went to Parliament, it brought tears to my eyes every time I watched all the people out
Yes.
cheering. People are cheering for you, and
I know.
it's cost you a lot, but
Everything.
at some point, your children are going to admire you for what you've done.
I know. So long story short is I live in Mexico now, and I flew back to Toronto end of November to actually go for my trial. I actually was offered peace bond. I joined the call when you were talking about peace bond. So I actually was offered peace bond, but I did not accept it because I wanted to have my trial. And because I knew that would, and the main reason why I want it is because my accusers, who's my ex and her new husband, I was actually granted an opportunity to cross-examine them myself because I'm a self-represented within criminal.
I was going to
trial
ask you that. Sounds like you're self-represented. You just keep in mind, judges hate self-represented clients.
Oh, I'm very clear.
And the best you can do is, just make it clear you're not trying to be a lawyer, right?
Well, the funny thing is not funny.
If you try to use legal language and you try to
Sure.
make yourself sound like a lawyer, then they get more resentful. So just be clear. It's like, I'm just a simple person, right? And I'm being persecuted for my political beliefs.
So what happened is they fabricated new breach conditions for me for the original bail hearing that I had. And when I arrived in Pearson Airport, I was arrested at the airport for 3 outstanding warrants. Same just for Facebook post and anyway, long story short, but I was denied bail. Long story short, I was naive to think that I will be granted bail and I would be able to go to my trial. They separated the charges, they denied me bail, and the Crown in the trial, when I was finally able to go to my court, handcuffed and then sit in a glass box, she literally said, off the record, because judge was not present, is that me winning my original trial, I would still be locked up because that's what they created. So I was forced to plead guilty in that situation because I couldn't stuck in jail for months or whatever, and have a 3-year probation for Facebook posts.
It's called The Deal with the Devil. There's a really great article written by a pretty good journalist quite a long time ago called The Deal with the Devil. They talk about why people plead guilty because it's actually easier for them to do that than to, they'll spend less time in jail if they plead guilty than if they were to wait it out.
Of course.
Terrible. It's terrible.
Okay. Well, I guess I'll reach out to Lisa.
She's got so much experience in all these different levels of pandemic cases. And she will be honest with you, most cases have not been successful. And she can tell you why. They're very disappointed, but you have to know going in that your chances of success are extremely low because it's too political for them, right?
I know. I was born and raised in Soviet Union, and my mother was a judge for 11 years in Soviet Union. So she told me once this whole ordeal started with me is that the courts will never rule in my favor because courts are designed to protect political agenda of the government. And that's
I just still don't see though. and maybe Lisa can advise you, because she did look at getting into family law at one point too. I just don't
Fantastic.
see, if you're guilty of some sort of political crime, I still don't see how that affects your right to see your children.
It's a long conversation, and I appreciate your time, but thank you, Diana.
No.
By the way, I shared into the chat this
Thank
ruling
you
was
for
literally just-
protesting. Thank you for doing your part.
Thank you. I actually shared the ruling. If anyone interested, this was just sent to me. This was probably one of the most fair judges that I had the pleasure to have back in summer, and I didn't even see this ruling until literally now whilst I'm on it.
Oh.
So if anyone wants to look at it, because it actually does discusses my protesting and everything, and my ex attempted to commit me to ChemH. So anyway, luckily he denied that.
That's terrifying. That used to be my biggest fear when I was a teenager, was, being told I was insane, and then how do you prove you're not insane?
Thanks, Vlad. Yeah, John, you're up next. Go ahead.
Thanks. Leah, just FYI, they're doing that. I know a half a dozen fathers that they're pulling that crap with. And so, yeah, you're not the only one. And I have a couple comments. One is, all the judges in Ontario, and I'm going to guess most of the provinces, they're all appointed. That's a recipe for corruption. And New York, for example, they got to be elected. At least with some having to be elected every 4 years, there's some accountability and responsibility on the part of the judges. There is none in Canada, period. Next is reverse onus. I haven't seen a case yet where the Crown hasn't screamed reverse onus. And 9 out of 10 times, it is not a reverse onus situation. And nobody's calling BS on the Crown. I don't hear the attorneys calling it. And I don't even hear the judge saying it's not reverse onus. How are they getting away with this? And why is nobody holding them accountable?
Okay. It's interesting, because I had thought about this election versus appointment of judges. And, what it comes down to is judicial independence. And judicial independence is so important to ensure that judges will be impartial. And, and at one point I thought there should be some accountability. An election of judges was maybe a good thing. But the reality is, what I've seen down in the States, especially, I looked really intensely into Oklahoma when I was working on the Daniel Holtzclaw case, that elections actually eliminate judicial independence because they need to get elected. So then they're concerned about what the public wants to see. And the reason we don't have public executions anymore is because the public enjoyed it too much. The public likes to see people get convicted. And so if the public is electing a judge, the judge is going to be more likely to convict, to please the public. And then they're going to be more influenced by what the media is saying about the case. It is so important that we have the judicial branch and the legislative branch, and they must remain independent and separate. And if you open it up to elections, then really what you're doing is you're making the judges people pleasers.
Yeah.
So I have to disagree with you on that one. Then
Okay. How about reverse onus?
the reverse onus, I absolutely agree with you that the prosecutors argue a reverse onus position all the time. They make some of the most specious, and we become fond of using that word, specious arguments in closing submissions about what an accused person has to prove or doesn't have to prove. And they take away the agency of a complainant when a complainant admits that they agreed to something. I've seen prosecutors argue, well, they can't agree because of authority, or because because they didn't realize they could say no. And I was like, how would you think this adult woman is a 2-year-old? Like, stop treating us like children. They'll actually take away, the agency that a woman's admitted to in court in their arguments. And if your lawyer is not arguing against that, I've seen Joseph get so mad at some of the Crown arguments, he slammed a highlighter on the desk and the cap went flying off it. So if your lawyer is not arguing against that, then maybe they should look at a different area of law, because we expect that. And in fact, one of my jobs at the firm is I predict, based on feminist arguments that I've studied intensely, I predict what the prosecutor is going to argue, and we put that into our closing submissions. We'll actually I call it doing the 8 Mile, where you actually take away all the arguments your opponent has against you at the beginning. We'll actually go in and say, oh, the prosecutor is going to say that JJRD, a case called JJRD, means that you can convict him just because you believe the complainant. No, JJRD does not mean that. If you convict, despite no problems with an accused evidence, it has to be because you have to explain why the complainant's evidence was so compelling. And in the case of JJRD, there was supporting corroborating evidence as well, that even though the accused testimony there was nothing inherently wrong with it, he still got convicted and it was upheld in this case called JJRD. It has been so abused by the Crown that he doesn't know it yet, but my future husband, Justice Pacheco, I know he's married, but he hasn't met me yet. Anyway, no, I like to joke about it. He's brilliant, and he should be on the Supreme Court, but I'm glad he's in the Ontario Court of Appeal because he's writing important decisions that we need while he's there. He's written an article, I believe, just to counteract JJRD and how prosecutors are using it. It's called Rethinking WD. And it's, he's single-handedly saving our appellate courts, I believe. Well, there's a couple of good judges on the appeal courts, but Pacheco is amazing. Reverse onus, absolutely. The prosecutors will do whatever they can do to get away and try and get away with it. I've gone to court in one case where the prosecutor made philosophical arguments about how the law of consent should be changed in this particular case. I was like, you can't just change the law because you don't like it. And the judge, thankfully we had a great judge, and it was only provincial court, Justice Ray. She was amazing. And she actually started laughing with him about postmodernism. And I knew she was on our side. He got acquitted. I knew she was on our side as soon as he started making jokes. She started making jokes about postmodernism. As well, some people would say that's all subjective, wouldn't they?
Yeah. Two more comments. The other thing is I see bail hearings going on for half an hour, hour to. I tell you, in New York, where I'm born and raised, there'd be an appearance ticket, and they got 2-hour bail hearings going on. It's absolutely ridiculous. I never seen anything like it before in my life. And they're holding mini trials, and that's where a lot of the backlog and nonsense is going on in these courts. And the other big one is they're arresting people and they're not getting them an attorney right away, and they're making all sorts of excuses. Shouldn't they be released if there can't be a judge in 48 hours? Shouldn't the arrestee be released?
Well, there are some rules on extensive incarceration waiting for a hearing. So but there's certain things that can be going on. I mean, first of all, without giving you an attorney, all they have to do is give you a phone call to a generic hotline, and the person is only going to tell you, don't talk to the police. That's all. That's the advice you're going to get, and they met their obligation, right? So there's not a lot to be said about that, as long as they give you that one phone call to that little 1-800 number or whatever, just so a lawyer can go on the phone and tell you not to talk. Then they've met the obligation there. But bail is a growing problem right now. It's not. I don't work on those cases. Those are more technical things that other people do behind the scenes, and I'm focused more on the trial part for the allegations. But I do know that that there's a massive call for reducing access to bail. You're supposed to be presumed to have bail unless there's compelling reasons why you shouldn't. But it's going in the opposite direction now, because we've had unfortunately, every time somebody's out on bail and they commit another crime or murder somebody or whatever, then there's this whole big thing saying we should not grant bail to anybody who's charged unless they want to reverse the bail onus. It's not currently the law, but there's a lot of pressure, and they're trying to change the law to deny bail. And especially with charges of domestic violence, that unfortunately some people will resolve with a guilty plea to a domestic violence charge because they just simply want to get back home, and even the complainant wants the person to be back home again, so they'll end up taking a guilty plea. And so now if you have a previous conviction of any sort of domestic violence charge and you're charged again, then you're denied bail automatically unless there's a reverse onus for that. they tried to make it that anybody charged with domestic violence at all, even for the first time, would be denied bail, but they failed that. But they did get it in place that you're denied bail if you have a conviction.
Sorry, John. You're I'm not sure if you're muted.
Yeah. No, I'm just going to say, God forbid they follow the Charter or the Canadian Bill of Rights, where it's required
Well,
reasonable bail.
like we mentioned, there's section 1 on the charter, right? So
Yeah.
they deem it in the public interest to protect women.
Yeah.
Thanks
So
for
I
the
don't use
question,
the
John.
Charter. Thank you.
So just in lieu of, I guess, or in
Just
addition to
quick,
John's
what was
question,
the name of that article, Diana, by the appeal judge? What's the name of the article? I'm trying to Google it so I can read it.
So the article by which?
You said the judge wrote everything WD. Everything
Thinking
W.
Okay. Yeah, I might have to provide that to Gavin. He can share it because
Okay, please.
it took me a long time to find it. I actually had a prosecutor friend of mine send it to me.
Okay.
So
I'll
yeah,
have to read it.
won't
Thank
be
you.
able to find it. I even had Quick Law and I couldn't get it on Quick Law. So
Okay, thank you.
I'll give it to Gavin and he can share it.
Thank you.
sounds good. Thanks for the question, John. Just kind of in addition to what you were saying, and also in lieu of what Diana said earlier on about Bill C-40, which is Milgaard's law. The press conference for Milgaard's law, I just put a link in the YouTube chat. There's a condensed version of the press conference that effectively talks about having an independent committee set in place that is not accountable to Parliament and also not accountable to the judiciary, which can independently review wrongful convictions, which I think is what Diana was talking about earlier on. But I think, in the States, there are prosecutorial integrity units that review, what is a district attorney in the States, what's a crown attorney in Canada. And I think we need to have the same kind of level of prosecutorial integrity units put in place in Canada. I think it would solve a lot of problem if there was some accountability of the Crown prosecutors. Last comment.
I want to be careful what I say because I do work for a law firm, so I can't disparage the legal system in an unfair way. But I think it's fair enough to say that there are prosecutors who've expressed frustration because they weren't permitted to withdraw charges when they didn't think it was worth prosecuting, and that's a serious situation.
Yeah, for sure. Last question. I don't want to be respectful of everyone's time. Dale, go ahead.
Yeah, I just wanted to say something quickly here because I did have a bit of a question for this because I was a whistleblower for COVID in early 2020. I uncovered a delivery system for aerosolized biological weapons that was designed to look like a random outbreak, which is how they implemented the pandemic response. And I reported this to the RCMP. What ended up happening, my family matter was weaponized after I went ahead to report this criminally. And then I took them to court because of the failure to investigate. And I had the same judge on both matters on the same day. First appearance, the judge directed them to RCMP to keep me out of the court. I was then subsequently tortured by the Saskatchewan Health Authority and the RCMP and drugged and interrogated under the Mental Health Services Act about the same subject matter of what I was taken to court and reported that, which is high treason, a delivery system for bioweapons is an act preparatory to levying war. It came from the United States and also originated from the CDC and should have been reported to the United States authorities, which it was not. It was concealed. My oldest daughter, was also done. And my youngest daughter was taken into family court by the same judge who was supposed to deal with the COVID matter. And they both did away with both of them, stripped of everything that I had, and so was my daughter. My daughter was taken to her workplace at the Saskatchewan Health Authority and then interrogated and tortured for information as well, under the guise of COVID quarantine. She's went to the United States and then was arrested at the borders in Indian Crossing at Sweetgrass, Montana on October 1st to prevent that evidence from going to the States. DHS concealed it, and she's been trafficked in one form or the other the last 3.5 years, ultimately ending up in an outright attempt in her life on October with the consent of the RCMP and DHS and numerous courts in Canada and the United States. And so I saw a lot of fraud in the courts and outright criminal activity being concealed because it would have shut down the COVID response in July of 2020. No one would have gotten a shot. And I'm actually getting more help with the United States than in Canada, because in Canada, they try to brush everything into family matter and conceal it that way when it's actually not true. And I even had a writ of mandamus that I had filed in the Court of Appeal for Saskatchewan that was incidental to my appeal, because the political persecution and trying to torture me and my children were affecting my ability to litigate, as well as the clear violations of the human trafficking laws by the financial and the sexual exploitation of my children with the consent of numerous parties. And so you know, I have strings of judges and registrars and so forth outright lying and concealing criminal activity, especially when it comes to high treason and interfering with other countries. And so when you look at a situation like that, I mean, this is something that demonstrates there's a huge problem with the legal system, especially in Canada, more so in the States, because they can't get away with what they're getting away with here. And so it's like, in a situation like that, where does that go? Because if you can do this to somebody in Canada, then nobody has any rights whatsoever. And this is where restraint needs to be happening, and it's something that needs to not be ignored, because I've been working more so with parties in the United States, and like the guys that wanted the military accountability, they've taken my information. I'm working with actual politicians that are in state and federal Congress in the States, and people who are running and so forth. But in Canada, not the same thing. So where would you suggest dealing with this in that kind of manner in Canada?
Dale, can I just jump in to add, and this is part of the same question. So what we did with the mayor of Chestermere, that mayor was gonna, part of what that mayor was putting in place to go for the ACERT investigation was all of Dale's stuff. And that was part of the reason why that entire council in Chestermere was taken out that was doing it, and also that the ACERT investigation was stopped that we were working on. Like Dale and I busted it. Dale busted it, and every time we make an attempt to do anything, they shut us down.
Yeah, because no one would have got a shot. Like, everything would have been shut down in 2020. And so this is a problem, because the people who did this are responsible for every person dead on planet Earth from that vaccine or injured.
They really pressured my daughter to get a vaccine when she was pregnant. She'd already had a pregnancy scare, which thankfully turned out to be unfounded. And you know, then I had my reaction, which was, it had to do with reproductive system, and I was so glad she never got it. But you know, one of the things I have on my Twitter profile is a featured tweet from a long time ago, is like, defending other people's rights is defending your own rights. It's something along that nature, that if you can't defend other people's rights, then you're giving up your own. And you know, people need to keep that in mind. There's a reason why, you know, sometimes guilty people do go free, but it's to protect the right of the innocent to not be wrongfully convicted. And we need to understand what that means, because most people, when they're wrongfully accused and then hopefully not wrongfully convicted, they never expected it to ever happen to them. And that's usually the first thing I hear from people. I never thought this could happen to me. I thought it happened to other people. So, you know, so that said, in terms of your story, and I'm sorry that's all happened to you, there is a case that's in the court system right now where a woman in I think it's Alberta, but it's in the Prairie provinces. She was denied a transplant because she refused to get a vaccine, a life-saving transplant. And they said they refused to do the surgery unless she got the vaccine, and she refused to get the vaccine, and she's currently litigating on that issue. There's a lot of people who are bringing really heartbreaking cases forward about being compelled to basically become human experiments for the government. You know, and I'm on par with you that it's not really the point of, you know, the meeting here right now to get, because I could, like I said, I was obsessed with this for years. I know
Yeah.
Lisa Bildy and BJ Dichter and the freedom protests and all the stuff, like, you know, I've been heavily involved in that. But I think, you know, the important thing here now to realize, and you were calling it the legal system, the important thing to realize is it's not a justice system, it's a legal system. And if you go in there thinking that justice will prevail and you have charter rights, you're going to be vastly disappointed. It's about words and it's
Yes.
about cleverness.
Yeah, that lady actually did die, Diana, and I mean, every life is matters, but the one that really broke my heart completely is a 35-year-old father of 5 children from Sudbury that died because he was denied kidney transplant last May. So
Yeah.
it's
When
horrific.
when you see this stuff happen, when you put it in perspective in terms of, you know, people saying, well, I was falsely accused and where's the evidence? Where's the evidence? There's no evidence. And we always try to remind people, testimony is evidence. All they need is a person willing to come forward and saying, this person did this thing to me. And then the police, their number one job is to lay a charge. And then I had a prosecutor friend who actually gave me a walk through the prosecutor's office, and he shows me, oh, this is where all the incoming charges go to this big table, and there's like 6 or 7 prosecutors sitting there reviewing all the incoming files, and they look at it, and they only look at what they're being told by the police who have a goal to lay charges. They look at those reports and they say, okay, we're going to lay this charge and this charge and this charge. And then it's up to the defense lawyer to get the prosecutor who's then, because then those prosecutors take the case, put it into a mailbox for another prosecutor, says, okay, we're assigning this one to you, right? And they're being, some of them are being vastly overworked, right?
Quickly, Diana, I know we're probably wrapping up. Just want to make sure I don't forget. I don't know if you're familiar, but there's a detective, a female woman detective from Ottawa that actually attempted to investigate deaths of newborns after they were jabbed. And she's on a trial herself right now. And the criminal Ontario government, and I'll make that claim myself, denying Zoom access to the public to that proceeding and only allowing in person. And the same thing happened with me, same happenings with Randy Healer. They denied Zoom access to this criminal proceedings, which is in the best public interest, but they're just so scared of people knowing the truth.
Well, I think
Well-
that's a good point to end on, because I think what it ties it back to me is the brilliance of what Gavin is doing here and what Gavin's put together in getting people to share their stories, to have the confidence to speak out and to try and take action and do something. Because if you want to just file a document in court, well, you're not going to get anywhere. What you need is the power of people, and you need people coming together, because I think that's one of the problems in our world is that people forget how much power they actually have. And this kind of group is a good reminder. And, you know, I try not to be too much of a downer, but I try to be a little bit realistic so people don't get too convinced that they're absolutely going to win. I mean, in a way, positivity helps you to be successful, but at the same time, you have to be realistic. Like I said, we go into every case, no matter how good it is, we go into every case thinking our guy could be convicted because we don't like to lose. So it's good for you to understand how much the odds are against you whenever, and assume they're all against you, and be ready to fight. And you know, this kind of thing that, like, I'm so impressed with what Gavin has built in such a short time. And so I'm really thankful to be here. And I hope I gave you all some helpful information.
Thank you. Thank you so much.
That was amazing, Diana. Thank you very much. I really appreciate you taking a couple hours of your Sunday to spend with us today. And who knows, maybe we'll set up another one of these for a month or two down the road and see how that goes. But on behalf of everybody from False Allegations Canada and Complex Trauma Canada, really great to see you. Thank you very much for your time. I think we got all the questions answered. Somebody posted a question about, as a man, is it good to identify as a woman if you're facing sexual assault charges? But I think that was more facetious. But anyways.
I would, like I said before, you should identify as my pronoun is innocent. Or you can have a little more cheeky fun and say my pronoun is Your Honor.
There you go. Okay. Well, on that note, thank you very much to everyone for attending. Thank you very much, Diana, for being here. And I hope you have a great rest of your Sunday. Thanks, guys.